All right. You may proceed.
Okay, thank you, Judge. To begin, before I forget, I'm going to bring a case up. I won't reference it till later, but if I may approach, Your Honor.
Usually more case law.
So, Judge, as you're aware, my name's Jake Evans. I represent Petitioner Tracy Wheeler in this case. We've now had 2.5 days of evidence and testimony, and the evidence is very clear on this issue. I understand the respondents have tried to make way of every which way they can to try to not have a new election, but we're going to go by one and establish that a new election is pretty clear. So I'm going to refer throughout, Your Honor, to Exhibit 22, which is our voter chart. I also will reference Petitioner's Exhibit 15, which is the chart presented by McDuffie, which admits a lot of the underlying issues, and Ms. Brooks referenced in her testimony. So to start, what I will do is start what I'm going to regard as the 27 that are admitted, the 27 that really are not in dispute in this case, because I think that will narrow and simplify the issues. There are 24 from McDuffie that have not been disputed to receiving the wrong ballot. Those 24, Judge, are, if you look at our Exhibit 22, in the right column, we go through and say McDuffie admits received wrong ballot, McDuffie admits received wrong ballot. Those go down. The one that was added during trial was Miss Sarah Rogers. Miss Sarah Rogers was the individual that lives in Columbia County. No part of Columbia County is in House District 128. She was assigned to House District 128, and she received a ballot for House District 128 according to her voter certificate. She is not being disputed by McDuffie. So I also reference the court to Exhibit 15, which Ms. Brooks we utilized in her testimony. And if you go to the first 6 there, Judge, the McCords, the Sharp, Tiller, and Miss White. Miss White was one of the ones that testified. She's actually at Howard Street instead of Howard Road. Those have been admitted. Those have been 6. There's no dispute they received the wrong ballot. The next batch, which is 17 voters, this is referring to Petitioner Exhibit 15. Those were admitted. Ms. Phyllis got on the stand and testified that those 17 received the wrong ballot. And then on the final page, we have Ms. Sarah Rogers. I just referred to her. Ms. Phyllis testified she received the wrong ballot. So that is 24 from McDuffie that are not disputed. There has been no evidence in the record that disputes they received the wrong ballot. We are starting at 24. The next 3 are Warren County. Warren County admitted these folks were either assigned to Warren County but shouldn't have been, or outside of Warren County and should have been. Mr. Davis went through, showed via combo code, showed via the underlying ballots, which are before Your Honor, that these individuals received the wrong ballot. There is nothing in the record that disputes that the 3 from Warren County, in fact, received the wrong ballot. You have the ballots yourself, Judge. You've got the voter data. You can confirm that. That puts us at 27. So to start our analysis, we are at 27. I will then go through the remaining batch one by one in order to continue to simplify this as much as I can for the court. The 3 movers. The 3 movers came in to testify. We first had Ms. Bauer. She has her affidavit, which is also before the court. Opposing counsel had an opportunity to cross-examine her, confront the evidence presented against themselves, and she testified. She moved to Georgia Southern, or she moved to Statesboro in 2019. She graduated from Georgia Southern in December of 2023. She then got a full-time job in January as a music teacher in Bullitt County, and at that point she said, I'm staying here. This is my new home. This is where I'm going to build a career, and she, at that point, testified this was my new residence. That is well more than 30 days before the election. I don't think Ms. Bowers did anything malicious, but she did lose her domicile and residence according to clear Georgia law at that point and testified very clearly. Now, the pertinent statute on this issue is 21-217. And effectively, 21-217 says, the residence of any person shall be held in that place in which such person's habitation is fixed. Where do they live? Where do they go to sleep every night? Where do they brush their teeth? And when they move, an individual moves to another county in this state, and with the intention of making that location their residence, they lose their residence in their former county. Both the Hardistys did exactly that. The Hardistys moved outside of, I believe it was McDuffie County, into Oglethorpe County. They built a house in July of 2024. They moved into that house middle to beginning of August of 2024. They physically moved. The house was furnished. There was no way their habitation was fixed in Glasscock or McDuffie County after they left McDuffie County. You cannot, and they did not live in a storage facility, period. The only reason why, and Mr. Hardisty testified, my residence for voting purposes was McDuffie, was because he was incorrectly told that had to be the case in order for him to vote. That's not proper advice. The proper advice would have been update your voter registration information for Oglethorpe County. You can go in and cast a provisional ballot. You can give us a bill which confirms that you live at this new address, or anything that confirms you live at this new address, and we will count your vote in the county in which you habitate and you live at, which was Oglethorpe. So that was a mistake by the poll worker that resulted in him maintaining his address because he wanted to vote, but that is not his habitation. I can't claim to live in, you name the county, McDuffie County. When I don't habitate there, I don't go to sleep there, I do nothing there. You can only live where you habitate, where your domicile is, and your domicile is analyzed by a number of factors, including where you pay bills, where your property, if you pay property taxes, where you go to sleep, all those factors. The Hardistys lost their residence. OCGA 21-2-217 makes clear they lost their residency when they moved to Oglethorpe in August. They did not and do not intend to return. They do not habitate in any way in McDuffie, and they reside in Oglethorpe more than 30 days before the election. All three of them testified. Those are illegal votes. Those are individuals that lack the eligibility to vote in the election. And they testified. They voted on every ballot, every race on the ballot, including House District 128. So that is 3 votes, which puts us at 30. So to begin our analysis as we move to maybe the more difficult ones, which I don't really think are difficult at all, we're at 30. So next, Judge, we'll go to what you have already properly indicated is clear, the voter certificates and what ballots that these individuals receive, which is what we've talked about, and I've talked about the White Oak 24. The evidence on this issue is very clear. It is very straightforward. There may have been confusion by Ms. Brooks, which has created confusion which really shouldn't exist. But we go back to the cold, hard documents. And the cold, hard documents Your Honor has, and that are these voter certificates. We have voter certificates for every one of the White Oak 24. And Your Honor can go through each of the White Oak 24 one by one by one and cross-reference these documents as I'm going to briefly show the court. Voter certificates, as Respondent Jackson's expert testified, as Mr. Davis testified, as Warren County's Judge Rachel's testified, as Ms. Brooks testified, are generated, you sign, and that is then generated once you sign almost moments immediately before you get your ballot. If you recall, Judge, I'm sure Your Honor has voted many times. You go in, you sign, they get your driver's license, they put it in. Once they put it in, they have you sign. This is what you sign. These are the signatures right here. And in this document, it says combo. And there's the combo, 132, White Oak, 132. Then they give you a yellow card. Your yellow card has the ballot that this voter certificate indicates. You pop it in, the ballot pops up, and you vote that ballot. We requested the ballots corresponding to the combo codes from the counties to get, okay, what is the ballot that corresponds to combo code 132? This is it. It's in the record. It's before Your Honor. For each and every one of the White Oak 24, they have voter certificates with combo code 132. 132. I have right before, and you have this in the record, Judge, ballot for White Oak 132. All of the White Oak 24 have the voter certificate with 132. 132 has House District 28. McDuffie County has admitted that none of the White Oak 24 reside in House District 128. They got the wrong ballot. That is unequivocally what happened. And to map it out and to go through a very tedious exercise that I frankly believe was completely unnecessary, but we did it because we wanted Your Honor to have utmost confidence, unequivocal confidence, that when a new election is held and ordered, it is unequivocally the right thing to do that must happen. We evaluated the voter data, which Ms. Brooks admitted, the voter data that was generated at the beginning of last year. There was generated the absentee ballot file that was generated as people are casting their early votes. The electors list, the people that actually went to vote, that shows the combo code. The absentee ballot file that was last modified as of November 21st, which is 3 weeks after the election. All of those documents show incontrovertibly the White Oak 24 got combo code 132, which here's ballot 132, which has the wrong House district on it. That is not controverted. It is not disputed. The cold, hard documents show that is exactly what happened. Now, Ms. Brooks may have sometime in December accessed Jarvis, which Jarvis is, as she admitted, a live platform that updates as people update it. And it may have said in December of 2025 that they were assigned to 125. And that happened because someone, we don't know who, went in, corrected the mistake, and they corrected the mistake by updating the street segment, which does not reflect on the audit history. That is what happened. Typically, when you have issues like this, the most simple explanation is the accurate explanation. That is exactly what happened. But frankly, Judge, we don't need any explanation because the best evidence, the incontroverted evidence is the voter certificate that was signed literally moments before, virtually immediately when the ballot was issued on the yellow card, and moments before the ballot popped up on the machine and was ultimately cast, these individuals got the wrong ballot. Point blank, period, end of story. Now, somehow claiming the inconsistency and there's uncertainty when there's really no uncertainty doesn't help their argument at all. In fact, I would argue if you're going to make an argument that inconsistencies happen and these people could have gotten a different ballot than what your voter certificate says, that blows up every reliability, integrity of elections in the state of Georgia. Extrapolating that argument out is reckless. It is entirely reckless to suggest that a voter certificate that has a combo code may have been inaccurate means every person in this room that voted in Georgia and every person in the state of Georgia that voted may have gotten a ballot different than a ballot certificate, than their voter certificate, should frankly not even be an argument made, and it borders on frivolous. And we need to be careful with the arguments that we make, because you have to think this case is not a simple business case. This is a case that's being followed by the public, and this is a case that people are going to pay attention to the ruling by Your Honor. But regardless of how you cut it, at a minimum, it's an irregularity here that really has no explanation, as Ms. Brooks said. But it really does have a very simple explanation. And the very simple explanation is they got the wrong ballot. The voter certificates show it. It was changed by someone in mid-December. We don't know, maybe the Secretary of State. All of the cold, hard documents show that is exactly what happened in this case. That's 24 votes. That puts us at 54. It's a game, set, match at that point. It's over. That's 54 votes. There is a 48 vote margin. 54 is more than 48. Done. Even if all the movers were illegal votes, even if they weren't, you're still at 51. It's game. Just based upon the issues that have been stipulated by McDuffie, the few but 3 issues that were stipulated in Warren, it's game. I will also show the remaining votes were illegal or were also resulted from illegal ballots, wrongful ballots, irregular ballots, whatever you want to call it. But that ends the analysis. The next one, Judge, is the one in Glasscock. The one in Glasscock was Mr. Shelton, which is intriguing because that is the 11771 Edgewood Road. And as the court identified, better than I did, Mr. Shelton turned 18 last year. And when he turned 18 in July of 2024, he registered to vote. And when he turned 18, he registered to vote. And those are facts Your Honor can take judicial notice of. You saw the voter documents, which are in the record. You saw the date of birth. He was 18. When he was registered to vote, he voted at that address. That address, in the record, not disputed by any party, is in Glasscock County. And even more so, one person he was registered in Jefferson. The other person was registered in Jefferson, and one person residing at the same address is in Glasscock. So you have a clear issue and an uncontroverted admission and statement by the Respondents' Counsel that Q Public and where you pay property taxes is definitive. This individual pays property taxes in Glasscock. That's definitive. That's direct evidence. That's in the record. The only suggestion, which is complete and totally circumstantial evidence requiring conjecture, speculation, everything else, is, oh, well, they granted it to somebody else, which means he may not live there. There is nothing in the record. We have presented, he's registered to vote there. He registered to vote there in July of 2024. He signed under oath he was registered to vote there. That's direct evidence. Direct evidence trumps circumstantial evidence every time, as Your Honor knows very well. We have presented direct evidence he resides there. There is nothing in the record that says that he doesn't. And the only suggestion that he doesn't is because someone, maybe his mom granted it to his grandparents or his aunt. I don't know his situation. But that suggesting it just because a property was granted from someone that didn't have from someone with his last name to someone without his last name does not show or meet a burden to show he doesn't live there when everything else shows he did live there. He was a disenfranchisement. That right there puts us at 55. So then we are down to the final 3 in Washington. The final 3 in Washington, Judge, are the ones Mr. Davis went over. These are individuals that, based upon the district lines generated straight from the reapportionment office, uploaded directly onto, through a clear chain of command, a geodata platform. Google Earth shows these individuals live in Washington County. You saw the line. The line was right there. They may pay property taxes in a different county. I'm not going to say they don't pay property taxes in a different county. But what I am going to say is, based upon what Mr. Davis presented, it is clear that when you extrapolate the district map onto a geomapping platform, that the line, and one of them, it was Miss Daniels, is clear. Multiple, I would say by 400 or 500 yards clear, is in Washington County, or more accurately, in the district, but they were not provided a ballot for House District 128. That puts us at 58. So, looking at the issues collectively in totality, we should talk about the standard, which we've talked about already at length. The first point, Judge, is this is a civil case. In civil cases in Georgia, the standard is preponderance of evidence. Just like guilty people are presumed innocent, elections are presumed valid. I'm not going to dispute that. But the standard in this case, at the end of the day, is a preponderance of the evidence. I have litigated many of these cases. I have never had a case where we have more strong, cold, hard documents that show in a very methodical, deliberate fashion irregular ballots, illegal ballots, wrongful ballots, whatever you want to call it. In my other cases, the district misassignments enough resulted in counties conceding to new elections. The district misassignments, which have been admitted to exceed 48 alone for your everyday voter who wants to make sure that voters, that elections are properly done, cast into doubt the election. And at the end of the day, what Your Honor and every judge before this state and every person before this state should want, as I said in my opening, is to ensure elections are properly done, are fairly done, and if they're not, they're fixed. Now, what's before Your Honor is a unique fact set. This is a fact set where we have 28,000 voters that cast votes, and a margin was 48. Elections are not being overturned every day. They're rarely overturned. And when you have big margins, they're not going to be overturned. But when you have an election where 28,000 people showed up to vote in this contest, and it was ultimately decided by 48 votes, which ultimately revealed people were assigned to districts that they didn't live in, people got combo codes they shouldn't have, and people got ballots they shouldn't have. And apparently the superintendent can't even explain some of what she alleges inconsistencies, but I don't really think is inconsistency. The voters deserve a new election. Maybe the margin next time won't be close at all. Maybe it will be even closer. I don't know. But what I do know is, based upon these facts and based upon what's been admitted, based upon the testimony that Your Honor has heard, the evidence clearly shows that you have direct documents, direct testimony from the supervisors. And again, Judge, I give utmost credit for them coming in and admitting the mistakes. I want to put that on the record, and that to be clear to everybody. They have not, McDuffie particularly has went above and beyond in getting us documents, not hiding things. In no way am I suggesting they did anything wrong other than issues happen. But for the voters of House District 28 and statewide, there is no way that they can have confidence that we reached the right result because of the irregularities and issues that happened in this case. And that has undoubtedly been shown by a preponderance of the evidence. So finally, I will talk about the standard issue. And I know we spent great length at that yesterday, and I do not want to rehash that at great length again today. I know Your Honor does not want to hear that at great length also. And I gave Your Honor a case, and let me find it. You should have it, which is the Fuller case. The Fuller case is a 2008 case. And in the Fuller case, the Georgia Supreme Court states what the holding of the Meade case is. And this is on page 138, if you look at the second page. And in the parenthetical it says, where alleged irregularity focuses on the ballots themselves, not the manner in which they were cast, the number of votes necessary to cast the result of the election in doubt is ascertained only by the margin of victory. This case is about the ballot. It is not about how the voters cast the ballot. It is not about if the voter really lived in House District 28 or not. It is not about whether the voter voted twice. It is not about how any of these people cast it. They did exactly what they were supposed to do. They showed up to vote. They got a combo card, which was the wrong card with the wrong ballot. They popped it in, they voted it, and they left. Any suggestion that the Meade case stands for it's about the nature of the ballot is wrong. The Georgia Supreme Court has said, here's the holding. That is the Georgia Supreme Court's opinion on what the Meade case means in a subsequent opinion wrote by Judge Thompson. And so very clearly, and if you read the Meade case, you will walk away with this exact takeaway. The Meade case does not go for pages about the nature of a ballot. What the Meade case goes for pages about is that it is critical that voters are entitled to understand the ballot was legal as presented, and in thus voted, he acted upon a mistaken belief, and that's enough to vitiate such ballots. That's what the Meade case is. And it says page after page after page, that the ballots were illegal. And maybe that's the best word to use here, as opposed to irregular. And the Meade case uses the word illegal. Frequently, the Meade case calls illegal ballots. Your Honor used the word wrong ballot. It is the wrong ballot, absolutely. The record does not controvert it being the wrong ballot. But perhaps the best word to use is the ballot was an illegal ballot. It was in a ballot that an election official illegally gave to a voter. Because Georgia law, it was not legal to give voters ballots that they were not entitled to vote in. And so that issue has been addressed and has very clearly addressed it. Finally, Judge, I will say that no matter how you crack this case, and I have presented what I believe firmly under Georgia law is the right conclusion. And the right conclusion firmly under Georgia law is you have 55 illegal ballots and you have 3 illegal votes in this case. You have 3 movers who moved out, their domicile moved to the new county. You cannot have domicile at a place you don't sleep at every night. It's just not possible. That would be very problematic and result in a lot of voter fraud. I mean, your domicile is where you sleep at every day. But in this case, it is very, very clear, and the issues collectively, with a very small margin, have met the very simple threshold. And I don't want to overly complicate this. The threshold at the end of the day, for Your Honor, is are the results of this election cast in doubt? At the end of the day, that's what it comes down to. How we get there, I believe it's very clear how we get there, but have the results been cast in doubt? We have a 48 vote margin. We have 51 admitted issues. The only justification on some of those is unexplainable, inexplicable. I think it is very explainable, but even by Ms. Brooks' own admission, it's inexplicable. And so no matter how you cut this, we have to do the right thing and ensure that the voters of House District 128, the candidates of House District 128, and the people of the state of Georgia know that we have fair elections, and if elections are not properly done, we ensure they are properly done. So I reserve the right to respond to respondent's argument, but I respectfully submit to the court that this is a very important case. There are many people watching this case. You cannot have a case with more clear documents that show more clear things than what this case shows. And Georgia law affirmatively shows you have illegal ballots. This case is not about how the ballots were cast, but it is about the ballots themselves, in that these people were given the illegal and wrong ballots. So thank you, Judge, and I will reserve the right to respond.